Good evening. Welcome in Daily UPSC Editorial Audio Program. Kashmir in pole position. The Times of India. Political grammar of the article. A cubist innovation that changes lives. The Economic Times. Ominously anti-federal. The Hindu. Now the full editorial. Kashmir in pole position. The Times of India. Supreme Court bench right in its unanimous call. J&K special status was stopgap. Statehood elections are next steps. Times of India editorial. Parliament has passed the bill scrapping J&K's special status under Article 370 in August 2019. Yesterday, a five-judge constitutional bench of the Supreme Court through three separate but concurring judgments put a legal seal on the political decision. Nothing permanent about it. Judges' opinion were unanimous that the arrangement for J&K was stopgap. Both textual evidence and debates among Constituent Assembly members showed it to be a transitional arrangement dictated by then prevailing circumstances. It was never a permanent aspect of the constitution. Questions over the procedure, the legal process of hollowing out 370 began in 2019 with a presidential order that amended Article 337 and interpreted interpretative clause. The petitioner in the case argued that this was legally untenable as it allowed Government of India to do indirectly what could not be done directly. Where Supreme Court found fault, all judges' opinion found fault with Government of India on this procedural ground. However, this procedural flaw did not neutralize other changes that supported a legal case to nullify 370. What's left undecided is the reorganization of a state into UT permissible under Article 3. One opinion observed that conversion of the state into a UT has grave consequences and impinges on federalism. Such a move needs to be in strict compliance with the Constitution. However, these aspects remain unaddressed as the verdict did not consider the ground on which a state's status can be changed. Since Government of India promised a restoration of statehood to J&K, Supreme Court's recommendations, Government of India planned to restore statehood and thereby an assembly of elected legislature. Supreme Court asked that elections to J&K Assembly be held by September 30, 2024 under the legislation introduced to reorganize the territory after the nullification of 370. One of the opinion recommended a Truth and Reconciliation Commission to bring closer to decades of strife, restoring normalcy to J&K. Security in J&K has improved since 2019, but terrorists have changed tactics. The number of civilians killed through targeted terror attack has increased substantially since 2016, and Peer Panjal is emerging as a terror hotbed. The only durable solution is restoration of the political process via early elections. India's successful counterinsurgencies have always been capped by a political process that brought about integration. Political grammar of one article. There was no question of J&K's current status changing, but Supreme Court ruling that President had powers to nullify 370 takes as to the issue of constitution centralizing tilt and its impact on federalism. Arghya Sengupta, the writer, is research director with Vidhi Center for Legal Policy. This was the only way that the long and meandering tale of the Constitution of India's tries with Article 370 could come to an end. In most respects, that end has come on August 5 and 6, 2019, with the nullifying of the special status of Jammu and Kashmir by Parliament. Only the last rites were left to be performed. Supreme Court took some time, since this was very literally a state funeral, Parliament having dissolved the state of J&K itself. Proceedings in the Supreme Court took some time, but in the end there was no resurrection. no tuning the clock back. Supreme Court did what most expected it would do 4 years after the death that knell for Article 370 has been sounded. They gave it a ceremonial burial. Getting out of 370 check review. Legally, the nullification of Article 370 has been done deftly. The provision itself appeared to be a check review. Amending or nullifying it required the recommendations of the J&K Constituent Assembly, a body that had ceased to exist 6.5 decades ago. As it turns out, the Supreme Court saw this differently. The majority judgment held that the power to nullify Article 370 belonged solely to the President and it could be exercised even without a recommendation by the Constituent Assembly in the first place. It found a way out of the check review that even Abhimanyu added by the courts could not. Cast by Maharaja Hari Singh. This conclusion fundamentally recast the basic structure of the Article 370 itself. According to the article, and understanding that every government in independent India had the future relationship between the state of J&K and the Union of India would at least formally be determined by mutual consensus between the people of J&K and the people of the rest of India. This was a promise made by Government of India going back to its acceptance of the instrument of accession by Maharaja Hari Singh on October 27, 1947, where it assured the Maharaja that the future of the state would be determined by the reference to the people. Via a presidential writ, now Article 370 has been nullified without the people of JRK having as a voice in the process through their own representatives. So once 4 years had elapsed since that day, one can understand the natural disinclination of Supreme Court to insist that Government of India follow a different procedure. But to say that the President alone could render Article 370 inoperative is to renege on a solemn promise. It feels like the final nail in the coffin. The writ of Article 356, one could perhaps concede that Article 370 was in some respect an exceptional provision that required its own interpretive scheme, but the question of what can and what cannot be done under President's rule under Article 356 is a question that is not unique in any way to J&K. This is a constitutional question all the way down with significant ramifications of the future of Indian federalism. The Constitution with its significant centralizing tilt gives Parliament the power to redraw boundaries of a state or create a new state only after ascertaining views of the affected state legislature. How this ruling can play out? Imagine if a state such as West Bengal is under President's rule, can the Parliament now redraw the boundary of West Bengal and create Gorakhaland after taking its own view into account in the absence of a state legislature? Though this may seem politically far-fetched, the judgment of Supreme Court does not foreclose this possibility, especially since it sanctions as legal the recasting of J&K and Ladakh as union territories. But the issue is the Constitution, not Supreme Court. To blame Supreme Court for this would be missing the wood for the trees. It's right in saying that the Constitution, especially Article 356 itself, gives the President a wide swath of power to ensure unity and integrity of the nation. Perhaps today, almost 75 years on from the onset of the Constitution, it is pertinent to ask whether this centralized scheme of Constitution actually furthers unity or it now its chief antithesis. President Rajendra Prasad was president. Neither this judgment nor the nullification of Article 370 would have been needed had the words of caution of President Rajendra Prasad being followed. On September 6, 1952, Prasad opened that the power under Article 373 to modify or abrogate the article could not be used multiple times. When the J&K Constituent Assembly had done its job, it should make a recommendation on the nature of its relationship with India and the article should cease to exist. Both Nehru and Sheikh Abdullah differed in their reading, and Article 370 blamed the channel through which the Constitution of India applied to J&K, but Prasad deferred to elected leaders. The President, in keeping with the propriety of his office, deferred to the elected leaders and the special status of the state unwittingly became semi-permanent. Article 370 should have become dead later on January 26, 1957, when the J&K Constituent Assembly finished its work and the J&K Constitution declaring its inalienable connection with India came into force. Now, 66 years later, Article 370 has been formally buried with the imprimatur of Supreme Court. It is time for J&K to start a new life, one that holds greater promise than the Vex least one. Maybe all do better this time. A cubist innovation that changes lives. The Economic Times. Consider a remote area hit by an earthquake. Rescue teams fly in, however, they can't do too much since no local medical facilities exist there. Flying out the injured is expensive, time consuming, and could be hampered by inclement weather conditions to deliver required medical care in such situations. And the Arogya Maitri AdQ hospital has been designed to create by the Health and Defense Ministries and the National Security Council putting their heads together under Project Bhism Bharat Health Initiative for Sahyog Hita and Maitri. The flat pack field hospital can be flown to a disaster area by helicopter and assembled quickly. The recently launched pop-up hospital is made up of 72 waterproof solar-powered 38 centimeter 3 cubes each weighing under 15 kg and has small ICUs and operating theater and key equipment including a portable X-ray and ultrasound machine and ventilators. 5 trained people can assemble the cubes into a functional hospital in an hour, and each can treat to 200 patients. This innovation actually changes lives by saving them. Flash pack hospitals can be lifesavers as they can be reconfigured quickly. For example, if it is sent to an earthquake hit area, the medical team can pack more cubes containing equipment for bone injuries and remove some of the bleeding injuries kits needed for soldiers with bullet or bomb injuries. This is more than just jugaad. With its robust tech backbone and trained human resource, India must invest in such crucial public-centric innovations that solve the challenges of the world. Besides saving life and dealing with emergencies, such inventions can very well be diplomatic goodwill tools to build stronger ties with the world, especially fellow developing countries. Ominously anti-federal, The Hindu. The Supreme Court's J&K verdict has imperiled the rights of states. Editorial. The Supreme Court of India's verdict upholding the abrogation of Jammu and Kashmir special status under Article 370 of the Constitution represents not merely judicial difference but a retreat from the court's known position on federalism, democratic norms, and the sanctity of legal process. It is undoubtedly a political boost to the ruling BJP and an endorsement of its audacious move in August 2019 to strip Kashmir of its special status and bring it on a par with other states. However, it is also a verdict that legitimizes the subversion of federal principles, fails to appreciate historical context, and undermine constitutional procedure. The most potent attack on federal principles in the court's unconceivable conclusion that Parliament, while the state is unconceivable conclusion that Parliament, while the state is under President's rule, can do any act, legislate or otherwise, and even one with irreversible consequences on behalf of the state legislation. This alarming interpretation comes close to undermining a basic feature of the Constitution as enunciated by the court itself, and may have grave implications for the rights of states, permitting a range of hostile and irrevocable actions in the absence of an elected body. The government and its supporters have much to cheer about. The Constitution Bench had endorsed its stand and rejected strong arguments from the pioneer, especially the point that the government had acted in a mala fied manner by imposing President's rule preparatory to the intended abrogations of special status without the need to involve any elected representative from J&K. The government has adopted a complicated process to give effect to the ruling BJP's long cherished ambition of removing the state's special status. It had gone on to divide and downgrade it onto two union territories. It began with the constitutional order on August 5, 2019, applying the whole of the constitution to JNK and changing some definitions so that the state legislative assembly could recommend the abrogations instead of its now dissolved Constituent Assembly and as originally envisaged in Article 370. Ultimately, the court ruled that parts of the August 5 order were unconstitutional as they in effect amounted to amending Article 370 itself, which was impermissible, but in a peculiar twist, it held the consequential notification on August 6, declaring Article 370 as valid and that the President was empowered to do so even without the legal underpinnings of the previous day's notification that sought to bolster the validity of the action. The President could remove the state's special status without any recommendations. The court has reasoned that the Constitution of India has been applied incrementally from time to time even after the Constituent Assembly was dissolved in 1957 and that the removal of special status is nothing but the culmination of the process of its integration. Even if this line of argument is seen as objectionable, the idea that is in the absence the Constituent Assembly and in view of the subordination of JNK to the sovereignty of India, there is no fetter on the ground's intention to hollow out its residual autonomy is opposed to all canons of federalism and democracy. There is no doubt that JNK is not vested with any sovereignty. The court says Article 370 represents no more than a form of asymmetric federalism, and that additional features such as having a separate constitutional residuary power of legislation and requirement of its consent to some legislative subjects before Parliament can make laws on them. It will not clothe it with sovereignty. All of this is true, but how this can mean that historical obligations owed to it and promises made by constitutional functionaries can be blown away at the ruling dispensation's whim is beyond comprehension. Forgotten is the fact that the process of integration itself was by and large built on a constant dialogue between Kashmir's leader and a union government. The context and condition in which it acceded to India, the terms of the instrument of accession of the progressive extension of constitutional provisions with the consent of state governments over the years. The court's failure to give its ruling on whether the constitution permits the reorganization of JNK into two UTs is an astounding example of judicial evasion. It is shocking that the court chose not to adjudicate the question that arose directly from the use of Article 3 of the Constitution of the uh, first time to downgrade a state. The only reason given is that the Solicitor General gave an assurance that the statute of JNK would be restored. It is questionable whether a mayor's assurance of a remedial measure can impart validity to any action. At the same time, the court upheld the carving out of Ladakh as a separate UT. On this point, the verdict is an invitation to the union to consider creation of new UTs out of parts of any state. The court's position that there is no limit on the president's power or parliament competence to act on behalf of the state government and its legislature is equally fraught with danger. In particular, the reference to non-legislative powers of the state assemblies passes a significant threat to the powers dissolved to the states. A future regime at the center could impose president's rule to carry out extraordinary actions through its own parliamentary majority that an elected government in the state may never do. Some examples could be ratification of constitution amendments, abrogations of interstate agreements without withdrawal of crucial litigation, and bringing about major policy changes. The view that some of these may be restored by the subsequently elected government or house is of a little consolidation if action takes taken under the cover of President's rule cause great damage to the state's interest. This is a verdict that weakens institutional limitations on power, and while rightly upholding Indian sovereignty over J&K, it undermines federalism and democratic processes to a frightening degree. Thank you.